So what we're going to be talking about today is if you've been appointed to be a trustee, what are your responsibilities? I want to make sure you understand what the rules are. And I'm going to talk a little bit about important do's and don'ts. So just to making sure you understand things you should do and things you shouldn't do, and what responsibility you're taking on by becoming a trustee. We're going to talk a lot about the Trustee Manual, which is what we've designed in our firm to give you instructions on what to do, and you can always hire professionals to walk alongside you to make it as smooth as possible. So before we get started, a little bit about our firm. We've helped over 8,000 families protect the assets that they leave to their loved ones from divorce, creditors, and lawsuits. We've also helped over 900 families implement the plans that we've designed, and we've helped over 2,400 clients implement the plans that other attorneys have designed. And the reason why that's significant to you is because you're going to want to put together a plan and put it on the shelf and forget about it, because estate planning is kind of depressing. But the fact that we've walked alongside other families and helped them after they've lost a loved one means that we'll be able to walk alongside your family and make it as easy as possible for them. The other thing that's unique about our firm is we do both estate planning and elder law. So estate planning is what we're going to mainly be talking about today. Elder law is planning for protecting assets for Medicaid and for veterans benefits. And because we do both, we can adjust as things happen in your family. So you can meet with us at any one of our locations. We have an office in Denton, an office in Bartonville, and an office in Aubrey. And there are 5 attorneys in our office, so you can meet with one of the attorneys or you can meet with my legal assistant, Tammy. She's been with us for 15 years, does an excellent job meeting with people. So I have 4 books, and if you're interested in any of these, you can contact our office and get a copy. So the first one is the Who Gets Your Stuff When You Die. That's my most popular book. It's the one I've had for over 15 years now, and if you want a copy of that, we can send it to you. I've also got one that's living with Alzheimer's disease. Wrote that one because a lot of my clients are either dealing with a loved one with Alzheimer's disease or they have Alzheimer's themselves, and it's kind of walking through making sure you take care of yourself and just trying to navigate that. Last 2 books are kind of related to each other. One is Will Your Spouse Know What to Do If Something Happens to You? And the other one is Will Your Family Know What to Do If Something Happens to You? And both of those cover, in general, what your family would need to know or what your spouse would need to know if something happens. We also have checklists on our website that you can fill out and leave for your family, so that way they know where things are, know how to deal with those assets. So let me tell you a little bit about how this Trustee Manual came about. So years ago, I was actually talking to a lady who was in her mid-90s. She was actually in horrible health, and I told her that when she passed away, I would explain to her daughter what her responsibilities are, walk her through what she needed to do. And she looked me in the eye and she said, "Honey, what happens if you don't outlive me?" Now, you know, at the end of the football game when they pour the water over the coach, that's what that felt like in that moment, because I really could not imagine a scenario where I wasn't going to outlive the woman that I was talking to. Since then, I've had that conversation many times and thought through what does happen if something happens to me. So one of the things that I did after that conversation is I wrote this Trustee Manual. So the Trustee Manual is over 200 pages long. It covers all the questions that clients ask when they become a trustee. It also covers all the things that we can think of that might be pitfalls or things that can go wrong when you're a trustee. I also at the same time created a beneficiary manual, so a manual for your family, the people you're leaving money to, that walks through for them why the trust protects them, why they want to leave the money in the trust. Now, since the time that I wrote the 2 manuals, our firm has grown. We actually now have 5 attorneys in our office. There are also 18 support staff. And so because of that, there should be somebody here to take care of you even if something does happen to me. But the manual's there also to explain to your family what they need to do. So it really doesn't matter if you have the absolute best living trust ever if the person you've named to be trustee doesn't know how to drive the trust when they take over. Now, in this speech, I'm going to use a car analogy a lot. And so that when the trustee takes over the trust, if something happens to you, you either pass away or become incompetent, they need to know what their responsibilities are. So initially, the way your trust works is you create it. You specify who's in charge. You specify who's in charge if you can't be, and you put your assets in the name of the trust. So you're the one that initially drives the trust. You're the one that initially is in control until something happens. So if you become incompetent or pass away, then that successor trustee is going to take over. And when that person takes over, they don't get driving lessons. They don't have any instructions that tell them what they're supposed to do. And there's a lot of responsibilities once they become trustees. So we wrote this manual to make sure that they understand what their responsibilities in being trustee are. And one of the biggest advantages to a trust is that there isn't any delay. So they don't have to go to court to get approved. They don't have to go through training before they get approved. It makes it much, much easier for them to step in. But it does cause a certain amount of danger. So that's one of the things we're going to go over. So if they lack the training to do the job, they may actually wreck the car or mess up the trust because they don't understand what their responsibilities are. And if they jump behind the wheel without ever giving driving lessons, like I said, they might crash the car or they might violate some of the responsibilities they have. So one of the things that we recommend is once somebody becomes a trustee that they read through the manual to make sure that they know what their responsibilities are. So let's walk through what could go wrong with the trust. It is administered outside the court, and like I said, that's one of the advantages to it. The court is not going to supervise what your trustee is doing. But if they were to make a misstep or do something wrong, there isn't necessarily anybody there to guide them or to catch them on that. And one of the important things with the trustee is they're obligated, similar to a driver of the car, they're obligated to follow certain rules. So similar to if you were driving and you go above the speed limit and a police officer pulls you over, it's not an excuse that you didn't know you had to go the speed limit. Or if you run a stop sign, it's not an excuse that you didn't know you had to actually stop. Because we're actually obligated to know the laws, know our responsibilities, and it's similar with a trustee. They're obligated to know their responsibilities even if they haven't had training on what those are. The other thing that a trustee can do is they can either violate one of their legal duties or they could violate one of the rights of the beneficiaries, and we'll walk through some of that in a minute. The other thing to be aware of if you get named as a trustee is you have a risk of being personally liable. So let me tell you a story of something that happened with one of my clients. There was a lady who went online to create her own will. She had 2 children initially, so she had a son and daughter. Her son had passed away. Her son was survived by 1 child, so she had 1 daughter and 1 granddaughter. The daughter and granddaughter didn't get along, and she didn't feel that she could trust either one of them to be fair to the other. So what she decided to do was to put the 2 of them in as co-trustees, and she decided that they would be in charge together. Within a month of her passing away, they couldn't even agree to pay the bills. But the other problem was because she had drafted the will herself, she didn't put the right language in. So in the language, what she put was half the house went to the granddaughter because the granddaughter was currently living in the house, and everything else was split equal among the 2. Now, I was hired by a friend of the family that the 2 of them had agreed they felt like could be fair in administering the estate. And the friend of the family, along with several other people, testified that the lady who created the will intended for everything really to go half to each of them. She was just really concerned about the granddaughter having somewhere to live. But the literal wording in the document gave the granddaughter 3/4 of the house, and 1/4 of the house went to the daughter. We presented lots of testimony from this family friend and other family friends that the lady really did intend for the house to go half to each of them. Both sides hired their own attorneys to fight. The fight on the language actually ended up eating up a good portion of the estate. So the only asset in the estate was the house, and the house was worth about $100,000. And they actually spent close to $100,000 in attorney's fees fighting over what that language meant. So then what happened after that lawsuit was over, and the granddaughter's the one that won, so she got 3/4 of the house, daughter got 1/4 of the house, because that's literally what the will said, not what the woman intended, but what the will said. The granddaughter then sued the friend for a breach of fiduciary duty because he added a duty to be neutral as being the executor of the estate. And because he took a side in the litigation, he was not neutral. And this man actually had a lot of assets, and those assets were at risk, and he could have been personally liable for that. Now, he did end up settling the lawsuit with her. But one of the things to be aware of is the people you've named to be in charge have some risk that they might have personal liability for being executor or being trustee. So the other thing to remember is this manual is also important if you have a surviving spouse. So for married couples, the manual talks through what happens if one of you passes away, what the surviving spouse's obligations are. So a lot of our trusts, the way we create them, when one spouse passes away, the surviving spouse has access to all the money, can spend it on anything they need or want, but they have to leave whatever's left or what was left of them to the kids or nieces and nephews, charities, whoever they've agreed to. There's also a standard for the surviving spouse on what they're allowed to spend money on. So frequently it's health support, maintenance, education, travel's educational. They pretty much can spend it on anything they need or want. The only two restrictions is they can't gamble it away and they can't give it away to somebody other than who they've agreed with their spouse to give it to. So they need to understand that, and the manual walks through what their responsibilities are regarding that. So the trustee manual explains what needs to be done in plain English, or at least the best I can do with plain English. So I spent 3 years in law school, and one of the things they trained us in law school is to not communicate in plain English. So in order for us to write a manual and to explain to people in plain English what needs to be done, there are certain things that we do need to use legal language with. So let me give you some examples. So anything that the court or statutes have interpreted certain language to mean certain things, we need to make sure we use the correct terms. So one example of that is I had a client who tried to leave. He was trying to leave all of his real estate to his brother, but in his will he put all of my personal and business property. That didn't include real estate. So sometimes, even though plain language may make perfect sense to you and me on an everyday basis, if as an attorney we use something that may be clear to other people but not clear legally, we've just got to be really careful in how we phrase it. So one of the rules, and I'll talk to you about this a little bit more on one of the later slides, is when you invest money on behalf of the trust, you've got to do it as a prudent man would. And that's a legal standard, and it's what a person who is practical would actually how they would invest, but it's called the prudent man standard. And so you may hear me use that phrasing. That's also how we phrase it in the manual, but that's how the court cases have said the investments need to be done. So the other thing that's in the manual is practical step-by-step instructions on what to do. Now we used to, in the after somebody passes away section, the very first step was to contact our law office. And then I got a call on a Saturday night, it was midnight, and they wanted to let me know that their loved one had passed away. You don't need to contact the law firm that quickly. And really, it's probably better if you wait a while anyway, because once you've had a loved one pass away, you're going to be in shock from the grief, and it's going to be hard for you to make decisions. And so it's much better if you actually wait until a time when you're kind of out of that shock or fog before you start meeting with an attorney and making legal decisions on what to do next. The manual also includes valuable guidelines so your successor trustee can avoid the pitfalls. So the duties of the trustee, they fall into 3 categories. The first is they handle assets. So that's collecting the assets, making sure they're safe, valuing them and investing them. Second category is paying debts, expenses, and taxes. And the third category is making distributions to the beneficiaries. And I'll go through all these in a little bit more detail in later slides. One of the things you need to know is the rights of the beneficiaries. So the people listed as beneficiaries, they have a right to notification of actions you're taking. So if you are a successor trustee on somebody's trust, you can't secretly take over and not tell them you've taken over. You also have a duty to tell whoever the next beneficiaries are that you've taken over as trustee. They also have the right, if any of the beneficiaries ask for a copy of the trust, they have a right to a copy of the trust. And this is also an area that I get a lot of people asking me about. Should you include somebody that you're disinheriting? Should you leave them some money? The problem with leaving some money to somebody that you really just want to disinherit is it gives them the rights of the beneficiaries. So they have the right to demand an accounting, they have a right to demand a copy of the trust, and they have a right to demand an inventory. So they can make it really hard on the trustee. So it's actually better if you don't want to leave somebody something to seriously not leave them anything. List that you remember they exist, just that you're not leaving them anything, than to leave them some small amount of money which causes them to have the rights to be able to cause hassles. So the other thing that a beneficiary has a right to is information about the assets. So what's owned by the trust, what transactions there are, income and expenses. Other thing to think through is if you take over as trustee or you act under a power of attorney for somebody, keep really good records of all the expenses. So even if when you go to your siblings, you ask them if they want an accounting of what you're spending on behalf of mom, even if they tell you they don't want any sort of records, they're thankful that you're helping and they trust you to do it correctly, still keep good records. Because a lot of times what happens is when mom passes away and you actually then go to your siblings and show them how much money mom has left, one of the first questions is, I thought mom had more money than that, where did the money go? And so you need to have really good records so you can show them where the money went. And I would actually recommend that at least once a year you send your siblings a copy of all the money that's come in and all the money that's gone out and copies of statements. So that way, along the way, if they're going to cause you trouble, they cause you trouble along the way instead of waiting until mom passes away. You've also, one of the other rights of the beneficiaries is timely distributions under the terms of the trust. So one of the things that you're going to need to do or have an attorney do for you is read through what the trust says, because every trust is different and some of the language regarding the beneficiaries could be highly customized. So it could have language saying that there needs to be drug testing before there's a distribution. There could be language that you match income. There's lots of things that could be customized as to when you distribute money, and you need to make sure you're following that properly. And then I'm going to give you a couple of examples of when corporate trustees got in trouble for not administering trusts properly. So the first one was the parents had set up a $5 million supplemental needs trust for the benefit of their son who had a disability. There was a corporate trustee that took over. The corporate trustee managed the trust for 10 years, and during that 10-year period, they distributed no money to the beneficiary. Now, they took their fee for managing the trust. They actually invested the money well, but they spent nothing on the beneficiary. And when a family member realized that that was happening, they sued the corporate trustee, and the corporate trustee's response was, the beneficiary never asked for anything, so we never gave him anything. They also had never gone to see him. And so one of the things the court said is they had an obligation to check with the beneficiary to see if there was anything that they could spend the money on to make his life better. Also to check with the caregivers to see if there were things that could have made his life better. Because one of the things the court said is, wait a minute, the parents wouldn't have left him $5 million if they didn't want the money to be used for his benefit and to take care of him. They didn't want it to just sit there and grow. So second case where a corporate trustee got in trouble was a situation where the parents had left a trust for an irresponsible beneficiary. The irresponsible beneficiary went to the corporate trustee, and everything he asked for, they gave him. So they let him buy a really fancy car, they let him buy a nicer house, they paid for expensive trips. Anything he asked for, they said yes to. And then the trust totally ran out of money. Then he sued them, and the bank's response was, why are you complaining? We gave you everything you asked for. And his response was, my parents knew I was bad with money. They knew that if they let me be in charge of my own money, I would blow it. So the reason why they put you in charge was for you to help me allow the money to last for my lifetime and to tell me no when it actually made sense to say no. And they actually lost that court case. So they actually ended up having to give him money. So because of that, if you have a corporate trustee in place, the corporate trustee is going to hire someone to come visit the person that they're trustee over to make sure their current needs are taken care of. They're also going to hire somebody to make sure that the money lasts for that person's lifetime if there's enough to do that. But they've got to weigh those two things. So current needs relative to long-term, the money lasting for their lifetime. Your individuals you name as trustee have the same responsibility. So they have a responsibility to make sure that the person's needs are taken care of, but the money lasts for as long as it can. Now, if you only leave a small amount of money to the beneficiary, of course it's not going to last for their lifetime. But if it's enough money to last for their lifetime, they have an obligation to make sure that happens. So what actions need to be taken right away? If you're one of our clients, or the person who passed away or became incompetent is one of our clients, look for the trustee manual, because that's what's going to give you step-by-step instructions as to what to do. You're also going to need to locate all of the estate planning documents you can find, and you need to go over those with an attorney to make sure you understand what they say that your responsibilities are. And really your next steps depend on the status of the person who created the trust. So are they becoming incompetent? Have they passed away? What is it that's causing you to think that you need to step in? So if the person who created the trust is disabled, so has a disability where they're unable to make their own financial decisions, or they're starting to make bad financial decisions, then you need to look at the document to see how you step in. So the way ours are written is that if 2 doctors certify the person is incompetent, then you can step in as trustee and start taking over and managing their affairs. Other documents might say that there needs to be a court determination that they're incompetent. So you need to look at the documents to see how that's determined. Also, if they're disabled, if they're unable to make their own decisions, somebody needs to make medical decisions. But you need to look at the documents and make sure you're the one that was appointed. Lots of our clients will put one person in charge financially and a different person in charge medically. So it may be a matter of that they've appointed somebody to make medical decisions and a different person to make financial. So just make sure you're the right person to make medical. You're also going to look for a privacy authorization, a HIPAA authorization. So whether you're in charge medically or financially, that gives you the ability to look at medical records to see what's going on medically to see if you need to step in. So if the person who created the trust is rushed to the hospital, if you'll look in their wallet, they should have a medical emergency card. That gives the hospital access to their medical power of attorney, the directive whether they want to be kept alive on machines, privacy authorization, so that way the hospital will have that information right away. And then consult the section of the trustee manual on immediate actions upon disability to see what you need to do next. If the trustor has passed away, so the person who created the trust, if they've passed away, it's going to be a difficult time for you and the family. And really the good news with that is there's no deadlines that come up really fast. So the first deadline you're going to have that you have to get things done by is 9 months after they've passed away. So really you have some time. I've already mentioned with shock, it probably makes it sense to have a certain amount of delay before you meet with an attorney to try to move forward in doing things. What we found over the years, if you really want to meet with us sooner, and it's during the period of time you're kind of in that shock or fog, we usually have a meeting then, and then we'll have a meeting a few months later, and a lot of times people won't even remember fully the first meeting. So it's almost better to wait, but if you want to meet sooner, we can do that. It may just be a matter of we need to meet again within a short period of time. Other thing to not be concerned about immediately is paying bills. So don't be pressured into paying bills too quickly. So one of your obligations, if there's not enough money to pay all the bills, so occasionally there are estates like that where we've got a certain amount of money, certain assets are exempt from having to pay bills, and there's not enough money to pay all the bills. If you let one of the creditors bully you into paying them more than their share, you actually then are liable for the difference out of your own pocket. So if there's not enough money to pay all the creditors, you have an obligation to pay them proportionally unless you negotiate something else. Now, a lot of creditors, like credit cards, will actually, no matter what, whether you have enough money or don't, they will negotiate a lower amount if you just ask. So it may be a matter of if you go to them and say, if I were to pay you now as compared to making you wait several months, would you be willing to take a lower amount? And if you're able to negotiate a lower amount, then that's great, as long as you have enough money to pay all the bills. But credit card companies have kind of figured out if they call and they kind of bully you, they can usually get paid in full when other creditors are not going to get paid in full. So just be careful on that. Other thing that I hate to have to tell you is when somebody passes away, you need to secure the assets. And unfortunately, you need to secure the assets not only from strangers, but also even from family members. So one of the things you need to do immediately is change the locks on the house. The other thing we recommend is that you have somebody guard the house during the visitation and the funeral. Because if you think about it, you have publicized when all of the family and friends are going to be in one location, meaning the house is going to be unguarded. And there are lots of situations where the house actually does get robbed during that period of time. So get somebody to stay with the house during the funeral, just to make sure that it stays safe. Other thing is, like I said, sometimes you have to be careful about family. So one of our families many years ago, grandmother passed away. One of the granddaughters on the day of the funeral said she didn't feel well and she was going to stay at the house instead of going to the funeral, and she would guard the house. The other, her cousins, came home a little bit earlier than she expected. There was a U-Haul in the driveway and she was loading it with everything in Grandma's house. Now I have no idea how she thought she was going to get away with this, because if you think about it, she was going to have to explain why the house had been gutted. But if they hadn't come home early, I guess maybe she could have said she went to her own house and then it got robbed while she was gone. So sometimes it's even family members will take things. But be sure to secure the assets and resist being pressured by others to give them things. So if somebody just has a sentimental attachment to something in the house and they want you to give it to them before you divide the personal property among the family, you can't do that. You can't favor one beneficiary over another. Also, if you're really close to the person that passed away, make sure you take care of yourself and the loved ones during that period of time. And then you need to look at the checklist on immediate actions after death. So another question is, what if you are the successor trustee on a trust and the person that created the trust is starting to become incapacitated or is likely to pass away soon? Should we have any actions related to that? We would highly recommend at that point that you come in and meet with an attorney, because there's some things that we can do along the way. It might be a matter of, if they're starting to make bad decisions, they might let you step in as a co-trustee now to have a protection against them making bad decisions. Or they might be willing to resign and let you step in altogether. And if where they might pass away soon, we may want to restructure assets. We would definitely want to make sure everything's in the trust so that we avoid having to probate the will. Other thing is, if you have somebody who's in charge and they're not quite ready, the person who's in charge of the trust is starting to become incompetent, but they're not ready quite to recognize it, then one of the stories that I usually tell in order to get people to think through allowing somebody else to come alongside them to help them protect themselves is, my clients who have fallen for scams are actually my smartest clients. I've had some very, very smart clients fall for scams. They actually say that the top 3 professions that fall for scams are doctors, lawyers, and engineers. And the reason why is all 3 of those professions are used to being able to make decisions without having to ask others. We're used to being in charge. And so because of that, we're less likely to check our decisions with others to see if they're okay. So it's not a matter of when you say somebody might get scammed, it's not a matter of you saying you don't think they're smart. It's more a matter of you just want to make sure that they're protected in case they're vulnerable. Also, one of the other things to think about, if you're the surviving spouse and your spouse has passed away, they actually tell you not to make major decisions for an entire year. So having somebody as a co-trustee or somebody to help you make financial decisions at least for that year is a good idea to keep you from making bad decisions. Now, one decision that a lot of my clients have made and regretted in that 1-year period is selling the house. So I've had more than one person that's lost a loved one who's told me that they sold the house because they couldn't stand to be in the house without that person being there. They kept thinking they would walk into the room and they would be there, and that made them sad. And so because of that, they sell the house. But what they realize after they sell the house is that they're going to be sad even in the new house, and they miss having the memories or the structure of the current house. So if you have somebody, if you're thinking about selling the house, at least talk through with other people to make sure that it makes sense. What I would actually recommend is if you really do want to move somewhere else, you move somewhere else and you rent out your house for a period of time so you have time to make extra sure that you really are okay with selling it. Another immediate step might be looking at how do we protect assets. So in the event the person is starting to become incompetent, That might mean that they're going to need care at some point. So do we look at protecting assets for if they need Medicaid in the future, because Medicaid has a 5-year look back, or if they need veterans benefits, which has a 3-year look back. So it's an opportunity to do that as far as an adjustment in the documents. So before you take any action under the trust, you're going to need to consult the chapter on do's and don'ts. So I'm going to go through a few of the do's and don'ts, some things that you need to watch for, some of the ones that are some of the traps that a lot of people fall into, but there's a lot more in the actual manual. So let me walk through some of the key ones. So one of the first ones is collect and lock up valuable assets and documents as soon as possible. So if the person that you're managing assets for has either a safe deposit box or a locked safe, I would highly recommend that when you open either the safe deposit box or the locked safe, you have somebody with you that can be a neutral witness as to what's in there. Because a lot of times when you open up a safe deposit box, all it's going to have in it is valuable papers, but it's not going to have any other assets. And I have lots of clients who their brothers and sisters will, after they've opened the safe deposit box, say, wait a minute, I know mom always kept money in the safe deposit box, or she always kept jewelry in the safe deposit box, and they will assume that that person has taken it. So if you take a neutral person with you that can testify as to what was in the safe deposit box when you opened it, same concept with a safe once you open it. So that way it's clear, you can have somebody else know what was in there at the time. If you have a co-trustee, you need to establish communications, and even if you don't get along with the co-trustee, similar to the daughter and granddaughter that I mentioned earlier, you really don't want to allow that animosity to come out in any way in texts or emails or how you communicate with that person. One of kind of the rule of thumb with anything you write in a text or email, think about the fact that anything can and will be used against you in a court of law. So think through what you're putting down. How is it going to look if somebody puts that up in an exhibit in a court file? What I recommend if you're thinking about typing an email, so you're mad at the person, you're thinking about typing an email or a text to them, and mainly you're just trying to blow off steam by writing it out, do it in a separate place, like a Word document. Because I can tell you more stories than I'd like to of situations where people accidentally hit send. And once you've hit send, there's no pulling that text or email back. And so if you don't want it to go to that person, you need to either put it in a Word document or you could send it in an email to yourself and then copy it later if you decide you want to do it. If you're emotional about whatever communication you've had from that person, I recommend you let it sit for 24 hours and let other people read your response. And try your hardest to stay logical. So let me give you an example with a beneficiary. So if you have a beneficiary who's accusing you of taking things or demanding certain things or anything like that, I would respond to the logical parts of the request. So if they're accusing you of spending money on things you're not supposed to, then what I would do is I would provide them an accounting of what you have spent money on, but don't attack them emotionally the way they're attacking you. So don't respond with, but you stole from mom while she was alive, and these are the instances when you did things wrong. Just focus on what they're actually asking for and stay logical in how you respond, and think through the fact that, like I said, anything you say can be used against you. You also need to set up a completely separate account to pay expenses and to have income come into. So one in the name of the trust. So don't commingle it with your personal assets. It needs to be a totally separate account. Also, you need to establish communication with the beneficiaries, and similar to the co-trustee, you've got to be civil in how you do that. Think through what you're doing, and you need to be compassionate if they're excitable, and mainly if, like I said, don't engage. If they do say something that makes you mad, you responding in kind is just going to make things worse. If instead you keep it logical, it's going to be better long run. All right, let me go through some don'ts. Don't use your assets for personal reasons, no matter what your excuse is. So let me give you an example of somebody who got in trouble. So somebody was named as trustee of her dad's trust. She had accidentally been late on her credit card. So on her credit card bill, she was late on the payment. She owed $10,000. And because she was late on the payment, they actually increased her interest rate to a really high interest rate. She was getting ready to get money from another source in about 20 days. And so she decided she didn't want to pay that interest for the 20 days. And so what she did is she paid off that credit card with money from the trust, and then 20 days later she paid it back. She actually got removed as trustee by the court because that's a breach of her fiduciary duty using the money for personal reasons. So you got to be careful about that. You also can't favor one beneficiary over another. So if a beneficiary comes to you and says, I know we're all going to inherit at least this amount of money and I've got this reason why I need money, you can't give that beneficiary money if you don't give money to all the beneficiaries. Now you can if you want to. If there's enough money in the estate to pay all the expenses, you could make a partial distribution to everybody under the terms of the trust, but you can't do it to one beneficiary and not the others. Don't act alone if you have a co-trustee. So if the document says that you and the co-trustee have to act together, then you have to act together. Also, the document might say you can act independently, but anytime it says you can act independently, you still need to let the other trustee know what you've done. So you can't, when you can act independently, and that's not carte blanche, just do anything you want to do. You've got to make sure it follows the rules and you let the other trustee know what you're doing. Other important thing is don't commingle the money in the trust with your own money. So let me tell you another story of somebody. She actually had a very good reason to do this, but she got removed as a trustee because she did it. So this lady, she actually had a lot of money herself. She had an investment account with an investment firm, and because she had a lot of money, they were able to get her really good returns on her investments, and the fees for doing the investments were lower than they would have been if she had had less money. So her thought was, if I take mom's money and I put it in with my account, I can make me and the other beneficiaries more money. I can also, the trust will have to pay less in fees. The court removed her as trustee because there's no way for the court to tell whether she was intending to steal mom's money or whether she was just investing it the way she said she was. So you cannot commingle it with your personal money without there being a problem. Also, don't fail to promptly respond to reasonable requests. One of the problems with texts is a lot of times the other side will actually get a read receipt. So they'll get something seeing that you've read it, and they're going to wonder why you haven't responded. So in the event it's something that you feel like you need some time to respond, and you have read the text or email, I would recommend you respond with something like, got your text, got a lot going on right now, it's going to be a few days before I'm able to respond, and I'll get back to you on whatever date you're going to get back to them on. And that then gives you time to analyze how you're going to respond, maybe run it by the attorney, run it by other people, and then that way, but they're not sitting around wondering why you're not responding, because they are going to know that you've read it. The Trustee Manual itself has a checklist of immediate actions. It has instructions on how to review the trust to see what your duties and responsibilities are. It has a list of the trustee duties, the trustee powers. It tells you about how to invest. It talks about handling income and estate taxes, how to prepare an accounting, and how to make the distributions to the beneficiaries. So lots and lots of detail in all these areas. I'd recommend you look through it to see that. So you may be wondering, if you've been asked to be trustee, what am I getting myself into? And if you're the person that's creating the trust, you may be thinking, who in the world is going to want to be a trustee? So years and years ago, or several years ago, my aunt prepared a trust, and she appointed me as the trustee. Now, I've told you in some of my other videos, I've got a relatively dysfunctional family, and some of the dysfunctional family members were beneficiaries of my Aunt Carol's trust. And when Aunt Carol put together the trust and she asked me to be trustee, I highly recommended that if I wasn't able to do it, that she put a corporate trustee of bank in as the second trustee. And at the time she did it, I actually thought that when Aunt Carol passed away that I would actually decline to serve, because I know that there's a lot of responsibility in being a trustee. I also know that there's a lot of risk of liability. But when my Aunt Carol passed away, I knew that she wanted me to do the job. And because I loved her, I did the job. Now, I can tell you that there was some trouble along the way, and it was a very hard job to do. But similar to me, the other people you've named to be in charge, they're people that care about you, And the reason why they're going to be willing to be trustees is they care about you and they care about your family, and they're going to want to step in and be there to help. Other thing is, when they step in to be in charge of your trust, they can still hire people to help them. So they can hire attorneys to help them analyze the legal part. They can hire accountants to help them with the bookkeeping, and they can hire a financial planner to help them with the investments. So they don't have to do everything alone. They can call in help or reinforcement to help them walk through what they need to do. Also, they can be paid a reasonable compensation for the time that they've spent. So depending on how much work they have to do on your behalf, they can actually take a reasonable fee for that. And of the outside advisors, when you're actually hiring people to help you do it, I recommend you start with the attorney. So the attorney can help you make sure you understand what your role and responsibilities are under the trust, and then we pull in the financial planner and CPA to help you with those pieces. We would love to have the opportunity to meet with you, to get to know your family, and to walk you through how a trust can protect your family and what the responsibilities are for your trustee. We look forward to meeting with you.